Major news about the Second Amendment and the right to keep and bear arms came out of the United States Supreme Court today, but not in an obvious way, specifically in the major fight over whether or not Joe Biden's student loan forgiveness is constitutional and legal under federal law. We got some real insights into the future of issues such as bump stocks, the pistol brace rule, and the authority of ATF. Let's talk about it when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and New York Times bestselling author. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so. Show your love for the right to keep and bear arms. Okay, folks. Here on this channel, as you know, we don't just talk about the news. We sometimes try to give you the details of it, and some of the things that may not be obvious to ordinary people on the streets, we try to bring it to you so you are indeed the smartest person in the room, which is my goal for all of you in the Second Amendment community. So today you have certainly read about this major United States Supreme Court argument involving whether or not the Joe Biden administration, specifically the Department of Education, had the authority under the law, under federal law, to basically say that $500 billion in student loan debt would be forgiven because, in Joe Biden's opinion, there was an emergency associated with the pandemic, which gave the president the authority to simply waive $500 billion in student loan debt to people that went to college and beyond. Now, this is really important case. Now, you and I may be thinking, hey, this is about student loan debt. Why do we care, Mark? Why are we talking about this? How does this touch fingers with our right to keep and bear arms? The answer is it really does in a big way, and I'm going to give you some happy, good news. The oral argument today looked very favorable to the issues that matter most to us when it comes to the authority, for example, of the ATF to regulate things like pistol braces and bump stocks. Let me explain. So the issue today is whether or not, under existing federal statutes, did the administrative agencies overseen by Joe Biden have the authority in conjunction with the president to simply pull out a pen, pick up a phone, sign a document, issue a couple regulations, and simply waive $500 billion in student loan debt? Well, today was the big argument about whether or not that was permitted. And it is crystal clear that the majority of the United States Supreme Court thinks that there is no way, no how, that the President of the United States, with his administrative agencies that are beholden to the President, had the legal authority to make such a dramatic policy choice affecting this amount of money and this many Americans without first having Congress pass a specific law. This is a very big deal for not just the Second Amendment community, but for all people interested in limited government. But the reason why this is so important and telling is because if you look at the comments and questions made by the sitting members of the Supreme Court in the oral argument today, and I'm going to focus on Judge Roberts because historically people think that Chief Justice John Roberts is sort of the middle of the court. Some people refer to him as a squish. Some people make comments like that in the press. I'm not saying that's fair or not, but I'm just telling you what the perception is in certain quarters of American society. And the reason why this is important is if you look at what John Roberts said on the bench today toward the Biden administration, it was really, in many respects, uncharacteristically harsh against the role and the power of the federal government to engage in this kind of conduct without going to Congress first. The reason why it's important to look at Justice John Roberts is because, again, he's kind of viewed as more of the middle institutionalist of the road, a little bit less conservative in certain respects. You can argue this case, but that's the perception. So this is what John Roberts said at oral argument to the Biden lawyers. He specifically, repeatedly says, quote, "We're talking about $500 billion and 43 million Americans. How on earth is this possible that you don't go to Congress to get permission?" Is effectively what he asked. He basically went on to say that debt cancellation was really dramatically different than existing programs. And then here's a very interesting question he asked, quote, "Because there's a provision in the law to allow a waiver when a school closes, because of that, Congress shouldn't have been surprised when $500 billion is wiped off the books?" So he's very perplexed as to how on earth the president thinks he has the federal authority to make such a drastic change. And he goes on to also say, that, and this is also, I think, quite interesting, he really draws a distinction between people who are trying to set up like a small business. He says nobody's telling the person who is trying to set up a lawn service business that he doesn't have to pay his loan. And yet, John Roberts continues, these people that are going to be college graduates to make all this extra money, they get their loans forgiven and it's going to effectively be paid for by these small business owners. John Roberts, the Chief Justice, did not think this was fair at all. But the reason why this is so important is not specific because of the student loan debt. It's because the skepticism raised by Justice Roberts was so extreme in my view that to me, there's very little doubt if this current court sat on a bump stock ban case, which I think they may be getting in the Cargill versus Garland case coming out of the Fifth Circuit, which is Texas, or the pistol brace case, which may be coming down the line. It's pretty clear that this Supreme Court, as currently composed, clearly doesn't think that President Joe Biden and his administrative agencies have the ability to, let's say, have the ATF ban bump stocks or have the ATF, ban pistol braces or require there to be registered without acts of Congress. I mean, these are major policy choices affecting millions of Americans, and if you draw any conclusions from what the Supreme Court was asking, they were very belligerent, in a polite, civil way, of course, but they were extremely belligerent and hostile to the Biden administration, saying that, hey, we've got some old generic statute. This is very interesting. They're basically, the Biden says, well, years ago, decades ago, we have these laws that give us all this power to act in emergencies, and the Supreme Court's basically saying, come on, guys, you can't take some old generic statute and then start redefining and expanding, the power when Congress doesn't act. And what's also quite interesting is that the Supreme Court really, and this is quite telling, I think this matters big time for the bump stock fight and for the pistol brace fight. The Supreme Court basically says, look, if the president is going to usurp the authority of Congress and start acting, on their own unilaterally, doesn't that mean that Congress is going to be denied the opportunity to debate the issue and weigh in on the issue and usurp their role in the constitutional form of government? And I think that's a big argument, because if you wanted to ban bump stocks, which of course would be stupid to do so, but that's what happened administratively during the Trump years, or you wanted to get rid of pistol braces, which of course is another idiotic idea, but if you wanted to do that, then the proper way, theoretically, would be for Congress to debate it, have hearings, and then pass the law. But of course, by having the president go out and just do such a thing, you're denying the ability of our legislators, who represent we the people, to make these kinds of decisions. And the Supreme Court laser focused on that today. Now, the reason why this is all important, and sometimes you remember, you want to cheer for things that are good for the Second Amendment community, even if they don't directly tie into the Second Amendment community, but this is a big deal. If the Supreme Court comes out and strikes down the Biden attempt to give all this student loan forgiveness away, or strikes down their attempt, this is a huge precedent that can be used against the ATF and the Department of Justice and other examples, including, again, bump stock, pistol braces, ghost guns, whatever you want to call these other arguments. This is another precedent that can be used by the lower courts. Now, with that said, by the way, I want to just have a brief update in the Cargill versus Garland. Remember, I predicted over a year ago that when the Supreme Court denied bump stock cert petitions in other cases, I told you all, do not worry about that. That is noise. That is not where the focus should be. The focus should be, if you're interested in the bump stock case, which of course is, for those of you who don't recall, during the Trump administration after the Las Vegas shooting, there was a ban on bump stocks done through executive action / administrative code rules, basically through regulations and not statutes, and that was challenged all the way up. And I told you that I thought that the most likely case to go to the U.S. Supreme Court is the Cargill versus Garland case out of the Fifth Circuit Court of Appeals. You may recall that about 6 or 8 weeks ago, the Fifth Circuit Court of Appeals issued a powerful, like 50 or 60-page decision explaining how the ATF had exceeded its authority in banning bump stocks, because obviously bump stocks cannot be characterized in any way, shape, or form as an automatic weapon or a machine gun. They're a piece of plastic. It doesn't do that. So with that said, today, I believe, is the day that the Fifth Circuit Court of Appeals issued a mandate down to the lower court, which really just means it's administratively, they sent the case back to the district court for further proceedings. It doesn't affect anything in terms of the Supreme Court. The Department of Justice under Merrick Garland still has time. I believe it's 90 days. Maybe they can get an extension. I can't remember exactly those technical rules because I don't work for the Solicitor General's office, so I don't need to know those technical rules. But I think they have several months going forward to make a decision whether or not they're going to seek certiorari to try to unwind that decision by the Fifth Circuit Court of Appeals in Cargill versus Garland, which again, the Fifth Circuit found that a bump stock could not be viewed as a machine gun or banned through administrative law. And again, the reason why this all ties in is if the Supreme Court comes out and says that Biden lacks the legal authority under federal law for various reasons to forgive the student loans, that decision can be used against, among others, the ATF to cut back on their authority even further. I do think we're going to see in the next 12 to 18 months the United States Supreme Court step up and slap the ATF in the butt for their misbehavior. I think that's what's going to happen. I think the ATF has been flying too close to the sun. I think they've been doing it, frankly, because their political superiors have been telling them to do so. But I think they're going to pay a heavy price because I think their wings will be clipped. I hate to mix all these metaphors, but I think their wings will be clipped by the Supreme Court. I think the Cargill case is a great tool to do so, but I think what will happen is they will decide the Cargill case in a very favorable way to our team against the ATF, and then all the related cases that may be pending associated with the pistol brace rule, ghost guns, frames, receiver, whatever all the other ATF regulations are that are being challenged. I think all of those will then get re-reviewed in light of the Supreme Court's decision in Cargill versus Garland. That's my guess. And by the way, to the extent somebody out there asked the question of, well, if they don't take an appeal in Garland versus Cargill versus Garland out of the Fifth Circuit, what happens with the rest of the country? Well, if they don't take that, there's going to be other challenges in other parts of the country that will eventually get taken, because then you'll have a circuit split. You'll have like one court of appeals that says the bump stock is legal under law. The Fifth Circuit has already said it's illegal under the law. You'll have what's known as a circuit split at that point, and that will almost certainly give rise to a cert petition and a ultimate Supreme Court decision. And I think a Supreme Court decision on the bump stock case will be very favorable. And I can tell you that based on the questions I saw today in front of the United States Supreme Court in the student loan case, it's pretty clear that the Supreme Court is laser focused on cutting back on the authority of unelected bureaucrats to take away all of our rights, not just the Second Amendment rights, but all of our rights, and to making sure that the view of a limited federal government is upheld, because that is the constitutional view. And this Supreme Court seems very focused on this based upon things that they've done recently, including today's oral argument in this Biden student loan forgiveness case. Okay, folks, so I hope this wasn't too geeky for you. We'll talk to you soon here at the Four Boxes Diner. If you haven't subscribed, please do so. We'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.